I'm Minnesota State Supreme Court Justice Paul Thissen, and I'm really happy to have the chance to talk to you today a little bit about the work that our courts and judges do here in the state of Minnesota and why I think that work is so important. I'm the newest justice on the Minnesota State Supreme Court. I was appointed in April of 2018, so about 2 years ago, by Governor Mark Dayton. Before that, I worked as a lawyer for 25 years, both doing litigation, so appearing in court on behalf of clients, and also helping clients with transactions, with business deals, making sure that they went smoothly and they went according to the law, particularly in the area of healthcare and long-term care. I also served as a public defender for some years, representing criminal defendants in their appeals, particularly to the Minnesota State Court of Appeals and the Minnesota Supreme Court. And I served for 16 years in the Minnesota State House of Representatives, in the Minnesota legislature, including a couple years as the Speaker of the Minnesota House. And that experience is really important to me. It gave me a chance to understand how legal issues work. It gave me a chance to talk to Minnesotans all across the state about what they value, what matters to them, what they're afraid. And all of those things really make a difference in how I make decisions when I'm sitting on the Minnesota State Supreme Court. If there's one thing that I want to leave you with from the time we have together, is to understand how fundamental and basic the work of the Supreme Court and the Minnesota courts in general really is. Every day in our courts across the state of Minnesota, the issues that Minnesotans really care about, that really affect their lives in the most fundamental ways, get played out. Questions about whether you're going to be able to keep a roof over your head. Questions about whether your family is going to be able to stay together. Questions about whether our streets are going to continue to be safe and whether someone is going to lose their liberty, whether they're going to go to jail for something that they did. Whether an economic problem is going to turn into an economic catastrophe. All of these things play out every day in Minnesota courts in every corner of the state. And when you think about the issues that people talk about, whether in the presidential race or in the legislature, those institutions are really important. But where the rubber really meets the road is in our state courts every day. And I hope that when you think about our courts, you don't think about them as something that's remote, something that has little to do with your lives and with the lives of your neighbors and your friends. The courts have everything to do with some of the most fundamental things that we deal with in our lives, and the ability of people either to be prosperous and successful or to face challenges. And that's why I think the work that I'm able to do on the Minnesota Supreme Court is so important and can make such a difference in people's lives, and why it's really important we consider who those judges are and what they do, and that we pay attention to the work that they do. In Minnesota, like most other states and the federal system, we have 3 levels of court in Minnesota. And by far the most important level of court and the busiest is our district courts, our trial courts. There are trial courts in all 87 counties, in every corner of the state of Minnesota. And if you go out to your county courthouse, you're going to find a really, really busy place. In fact, our district courts hear about 1.5 million cases every year, everything from traffic tickets all the way to first-degree murder cases and everything in between. The main job of the district courts, and on the district court it's one judge who just sits in front of the parties and decides the case, their main job is to sort out the facts, sometimes with the help of a jury. When you have a dispute with someone, often you believe this is what happened, and the person that you're having the dispute says, well, no, the facts really were this is what happened. And so it's the job of the district court to figure out who's believable once they hear you sitting in front of them, and decide what the facts were, what actually happened. And once the district court decides the facts, what actually happened, that finding, those facts are decided for the rest of the case when it goes up on appeal to the Court of Appeals or even to the Minnesota Supreme Court. The second level of court in Minnesota is the Minnesota Court of Appeals. If a party is disappointed with the result that they get in the trial court, if they think the trial court decided the case wrong against them, they get an automatic appeal to the Minnesota Court of Appeals. The Minnesota Court of Appeals has to hear every appeal from someone who's disappointed with the trial court decision. The Minnesota Court of Appeals hears about 2,000 cases every year. So 1.5 million cases in the trial court that get filed, kind of winnow down to about 2,000 cases. But the Court of Appeals is still a very busy place. There are 19 judges. that hear cases there. They each issue about 100 decisions every year. And unlike the trial courts where there's just one judge that hears the case, in the Minnesota Court of Appeals, they sit in 3-judge panels. So all 3 judges hear the case, read the briefs, listen to the attorneys, and all 3 judges decide the case together. Now, if a party is not satisfied with the decision reached in the Court of Appeals, if they lost, they can seek review in the Minnesota State Supreme Court, the court that I sit on. It's the last level of courts in the state of Minnesota, and for most issues, most cases, the decisions we reach in the Minnesota State Supreme Court are the final word in a case. There are 7 justices on the Minnesota State Supreme Court, and we all come from a wide range of backgrounds, which is really important and helpful because we all bring different perspectives and life experiences to our decisions. It helps us to see the case and the issues when we discuss it from a wide variety of angles, which is really important. All 7 of us hear and decide every case together. Unlike the Court of Appeals, with a few exceptions, we get to decide whether or not we're going to take a case. Parties and lawyers who want us to take a case have to file a petition for review. We hear about 40 to 60 petitions for review each month. It takes 3 of the 7 of us to vote in favor of taking a case before we'll take it. The biggest exception, where we are required to take an appeal, is first-degree murder cases. We take every first-degree murder case because the consequences of a conviction for first-degree murder, which is going to jail for the rest of your life without any possibility of release, are so serious, we think that we need to take those cases. When deciding whether we're going to take a case, we consider a number of factors. The 3 most important factors are whether it's an issue that's going to have importance beyond just the parties to the case. If it's going to affect a lot of Minnesotans all across the state, in that case, we're much more likely to take the case. We're also likely to take the case if it's an issue that we haven't addressed before, if it's a new issue, a new statute, a new interpretation of law that the parties are asking for, or if it raises constitutional issues, whether a statute's challenged for being unconstitutional. Then we're more likely to take it. And the last issue, the last reason we take cases is because of the interest of justice. If there's something that seems fundamentally wrong or unfair about the decisions below, then we will take cases to try to correct that error or see if that error at least needs to be corrected. If we do grant a petition for review, and we grant petitions for review in about 15% of the petitions that are filed, we will get, first off, briefs filed by both parties. Briefs are usually a paper, a memorandum, about 20 to 40 pages long, where the party lays out the facts and lays out the reasons that they think that they should win. We review the briefs very carefully in all the cases that the lawyers cite. We review the factual record as well very carefully. And then we go to oral argument, which is a chance for the lawyers to come in front of the 7 justices and make their arguments in person. Each side gets about 30 minutes before the court. Most of that time is spent actually answering questions and engaging in conversation with the justices. Because the justices, we want to push back on arguments the lawyers are making, probe whether they really stand up under scrutiny, make sure that we're coming to the best decision and having the best information possible to make our decision. Immediately after oral argument, the 7 of us, and just the 7 of us, go into a conference room. We sit down at the table, and then one at a time, we go around the table. We explain who we think should win the case and why we think that party should win. We go one at a time and listen to each other very carefully. We don't interrupt until each person is done. After that process and all 7 of us have spoken, we may ask questions of each other and have a further conversation, and then we take a vote. It takes a majority of the justices to decide who is going to win a case, so 4 out of the 7. Although 70% of our cases we decide unanimously, and we work very hard to reach those unanimous decisions. It usually takes about 60 to 90 days after oral argument before we issue our opinion. And we take the job of writing our opinions extremely seriously. We write very carefully, and we try to think hard about the issues from every possible angle that we can think. And we do that because the opinions that we issue today are not just going to affect people all across the state of Minnesota. and including the parties, of course, today and in the next couple of years, but they're going to be the law of the state of Minnesota for 20, 30, 50 years. And they're going to be used by parties 50 years from now to make decisions in cases on issues that we can't really even imagine perhaps today. In fact, there's many cases that I cite that are 100 or more years old in the opinions that I'm writing today. So it's a big responsibility and one that I and my colleagues on the Minnesota Supreme Court take very, very seriously. There's just two more things that I want to cover briefly. The first is just to note that there are actually two different systems of courts in the United States. There's the state courts. Each of the 50 states has their own set of courts and their own Supreme Court, just like the one that I sit on in Minnesota. And then there's the United States, or the federal courts. And those courts also exist in every state, but they deal with different sets of issues. The laws passed by the United States Congress as opposed to the state legislature. And the highest court in the federal system, of course, is the United States Supreme Court. There are two main differences between the state courts and the federal courts. The first is that once a federal judge is nominated by the president and confirmed by the Senate, that judge serves for life. He or she has a life appointment and can only be removed for good cause in very extraordinary circumstances through the impeachment process. In Minnesota, it's different. We too are appointed, this time by the governor. We don't have to be confirmed by the Senate, but we do have to face the voters in elections every 6 years. And so when you next get a chance to vote, whether it's this coming November or sometime in the future, you'll have a chance not just to vote for president and senator and your state representative, but also for all the judges in your community and statewide. And I hope that you take that responsibility very seriously and learn about the judges you're going to be having to vote for. The other difference I want to highlight is that Minnesota has its own constitution. You're familiar with the United States Constitution, which sets out the structure of government, the three branches, and how they're supposed to interact with each other, and also includes the Bill of Rights. You know, the First Amendment, the right to free speech, the right to freedom of religion, the Fourth Amendment, which gives you freedom from unreasonable searches by the government. Minnesota has a constitution of its own, which also sets out how the branches of government are supposed to work together, and includes another Bill of Rights. And it matches in many ways the United States Bill of Rights, but it also includes some rights that aren't included in the U.S. constitutions. For instance, in Minnesota, there is a right to a good education that we enforce and make sure that the Minnesota state government follows. We also have a constitution that protects the privacy of Minnesotans more than the United States Constitution protects privacy. And we take those rights and the dictates, the mandates of our state constitution very seriously. And like with Minnesota statutes, under the Minnesota Constitution, when it's interpreted, when we interpret it, we're the last word. It can't be appealed to the United States Supreme Court. And so we take those decisions very, very seriously. The last thing I want to talk about is something that I care really deeply about, and that's the concept of access to justice. It's really expensive to have a lawyer, to hire a lawyer, and there's many, many, many Minnesotans who can't afford a lawyer, even though they have real legal needs and real legal rights that are under threat. Now, in a criminal case, we have a constitutional right in this country to a lawyer if you face the possibility of going to prison. That's in a case called Gideon versus Wainwright that was decided about 60 years ago. We don't have the same kind of right in what we call civil cases, so every other case where you don't face the chance of going to jail. Cases like when you get in a car accident, cases like family law cases, divorces and child custody cases, housing cases if you're going to be evicted from your house or your apartment. In those cases, you don't have a right to a lawyer, and again, many, many Minnesotans simply can't afford one. And that's a real challenge and a problem in the state of Minnesota. That means that there are tens of thousands of Minnesotans every year who either have to figure out how to navigate the court system and figure out their legal rights without a lawyer, which is really, really difficult, or have to give up their legal rights altogether. Now, we have some very dedicated lawyers in Minnesota who do what's called legal aid, who provide services to people who can't otherwise afford a lawyer for these kinds of civil cases. But there's simply too few of them to provide the legal advice that's needed. To put this in perspective, if you imagine the U.S. Bank Stadium where the Vikings play football, if every seat in that stadium were filled with a person, a Minnesotan, who can't afford a lawyer and has real legal needs, guess how many legal aid lawyers there would be to serve all of those people? Well, the number would be equal to the number of players on the field, 20 or 21 lawyers, to serve all of the people sitting in US Bank Stadium. Obviously, that's an unsustainable system. And here's why that really matters. If you think back to how I started out this conversation, talking about the kinds of issues that happen in our courts every day, well, those really fundamental issues are most often the ones where Minnesotans lack legal representation. For instance, in housing law cases, if someone is being evicted, the landlord has a lawyer about 80-90% of the time. The tenant who's being evicted has a lawyer about 10% of the time. In consumer debt cases where someone's trying to collect money because you owe them, the creditor, the person who is owed money, has a lawyer nearly 100% of the time, whereas the debtor, the person who owes the money, usually doesn't have a lawyer. It's about 0% of the time. Even in family law cases, about 70% of the people going through our family law cases, where it's about divorce and child custody and child support, keeping families together, about 70% of those parties go unrepresented. And if you think about what that means, first of all, of course it means that those individuals won't necessarily get justice. They won't have their rights enforced. But if you also think about it from a larger perspective, it really calls into question the fairness and legitimacy of our court system. If people who can afford lawyers can get a lawyer and get that advantage, whereas people who make a little bit less money can't afford a lawyer, then the system, whether it's unfair or not, seems unfair. It's something that we really need to fix, and it's not just up to judges and lawyers to fix it. It's up to all of us to speak out and say we need to make sure that we live up to the promise, the values that this country was founded on. If you think back to our U.S. Constitution, the preamble that says, "We the people of the United States, in order to form a more perfect union." Do you know what the first thing that follows those words are? To establish justice. Our founders understood that justice was the key to prosperity, to equality, to political participation, to all these things that make our country great. And if we don't have a system, or we have a system of unequal justice because people can't afford to get their rights defended, we're not living up to that value. So I really want to thank you for giving me a chance to talk with you today. I look forward to answering some of your questions. You can certainly email me with any questions you have at paul.thissen, Thissen, at courts.state.mn.us. And I'll be happy to answer those questions for you. Thank you very much, and I look forward to continuing the conversation.